What we have now is a test that was originally in the insolvency law of the UK, and the House of Lords, in particular Lord Hoffman, brought it into the common law, first in the case of Norman versus Theodore Goddard. So the case brings this rule from the Insolvency Act into the common law, and the rule from the common law has made its way into the Hong Kong Companies Ordinance in Section 465, and you'll see that the Hong Kong Companies Ordinance is essentially identical to the rule that we see in Norman. Another rule, and again I'm giving you a case without reading it here, you see another rule is in the case of Daniels v. Anderson. The Daniels case is extremely long, and this rule is basically dicta because it's sort of on the edge of the entire case. But it is a rule which is taken from Daniels, and it's a very useful one for you to understand. And that is basically that when we look at the function of the director, we're looking at the type of company and the activity that that company requires. Some companies are complex and they're very, very difficult to run. Other companies are quite simple. They're not complex and they do not require specialized knowledge. So in the easy company, a director may very well meet their duty of care. But if that same director applies a similar sort of behavior in a very complex and difficult company, then the director may violate the duty of care. So you do have to look at the company, its activities, the difficulty of those activities and their complexity in order to understand the function of that director as it will be measured when looking at duty of care. You'll see in a video which is attached to one of the slides that's coming up from Mr. Kelvin Wong, who is an extremely expert director, and he gives a little bit of an explanation of how the duty of care applies to people like himself in practice. And you'll see that this aspect of the complexity of the company and the complexity of the work is an important one. So let's look at what was the Norman rule and eventually becomes the Hong Kong statutory rule. Right? So a director of a company must exercise the reasonable care, skill, and diligence. And reasonable care, skill, and diligence is that which would be exercised by a reasonably diligent person with a general knowledge, skill, and experience that may be expected of a person carrying out the functions. Not the skill and experience of the person themselves, what they bring to the job, but what the job expects from them. That is function, and that is objective, although it allows us to adjust the subjective test to different size and shapes of companies. And if the director has special skills, if you appoint a lawyer as a director, then you expect that person to have special legal skills. If you appoint an IT engineer or an accountant as a director, you expect the person to have those special skills because that may very well be why you appointed them as director. So first of all, we're looking at whether the person is exercising the care, skill, and diligence that can be expected of a reasonably diligent person performing the function that that person does as director within the company. And then we look to see whether the person is exercising the care, skill, and diligence that that director brings to the job. And that will be primarily skills as an accountant, a lawyer, or some sort of a technical skill. And this duty is owed to the company, as I've said. This duty replaces the common law, including the city equitable sleeping director rule. So here, please do take a look at the video and the link, and you'll see that Mr. Wang is about as qualified, or Dr. Wang is as qualified as anyone could be to give you a bit of insight into the role of a director and how the duty of care applies to that role. Here I'll just sketch out, because I've asked you to read the Norman case, and I'm asking you because we do not have a good Hong Kong case yet on discuss the facts to which the duty of care applies. And the Norman case is a very interesting one. It's written by the top UK company law lord, Lord Hoffman. So essentially we've got a firm of solicitors which does complex estate planning with trusts. Andrew Bingham is a partner. Andrew Bingham represents the Sandra Miller Trust. Sandra Miller is later married and changes her name, and that's why the case is Norman and not Miller. Andrew Bingham votes against the current director of what the trust primarily owns, which is LB Investment Limited, asks that the person be removed and works for that end to be removed as a director of LB Investments, and seeks for appointment of someone else. Socially, through an acquaintance, there is a son of this acquaintance, which is Piers Quirk. And Piers Quirk is a very sort of regular and not terribly charismatic sort of a person. And Andrew Bingham comes to dominate Mr. Quirk when serving as a director. And that's understandable given Andrew Bingham's great expertise in the complex international tax matters that LB Investment is engaged in. Bingham then advises Mr. Quirk to invest funds in a company called Gibbon from LB Investment. And these funds are ultimately lost, as you can read in the case. And then the question is, has Piers Quirk violated his duty of care to LB Investments by transferring those funds to Gibbon Limited without more knowledge about the transaction or Gibbon Limited? When the funds are lost, the plaintiff acts against Theodore Goddard because Theodore Goddard has been managing this trust. And then Theodore Goddard goes against Piers Quirk. And so here you have some very skillful people, the partners of Theodore Goddard, among whom is Andrew Bingham. And you have one relatively inexperienced person, which is Piers Quirk. And he has got himself in a very difficult situation. Andrew Bingham is now disappeared. And so Piers Quirk is left holding the bag. You'll see in the facts and be able to decide for yourself to agree or disagree with the House of Lords on whether Quirk did breach his duty of care.